everyone. Hope you are all doing well and preparing for your exams. So today we are going to discuss about one more lecture or one more video on banker customer relationship. As you know, I have already uploaded 2 other videos with respect to this topic, that is types of relationship that exist between banker and customer and banker's obligation to maintain secrecy of customers' accounts. So you can watch those videos if you have not watched yet. And let me tell you that most of the topics which are asked in situation based problems are related to this one. So be prepared with this topic very well, so you can solve your situation based problems if they are coming from this particular topic. If you have not yet subscribed to the channel, then do subscribe to the channel so you don't miss the important video updates. Moving forward straight to the topic, we are going to talk about obligation of banker with respect to honoring the check. As we have already discussed that while we deposit certain amount of money in the bank, the person or the customer who is depositing the amount is the creditor and bank is the debtor. So the deposits which are accepted by the bank are its liabilities which are repayable on demand or otherwise. Section 31 of Negotiable Instrument Acts is laying down some statutory obligation to honor the customer's checks. So section 31 says that the drawee of the check having sufficient funds of the drawer in his hands properly applicable to payment of such check must pay the check when duly required to do so, and in default of such payment must compensate the drawer for any loss or damage caused by such default. So section 31 basically talks about banker's obligation to honor check. Bank has to honor or banker has to honor the customer's checks if they are in proper order, if it is having sufficient funds and everything. And if bank is defaulting from such payment, then it will have to compensate for the damage or loss. So what are the conditions or situations in which bank can say no to honoring the check? So these are the 3 things. First is talking about sufficient funds. Second is talking about proper applicability or of payment of the check, and third is talking about duly required. So bank is duly required to pay in what circumstances. Let us discuss this one by one. First, talking about sufficient funds. When a banker is going to honor a check, there has to be sufficient funds in the account. This is a common thing which you can understand. So basically, funds must be at least equal to the check amount. So whatever funds that are lying in the account of the customer should at least be equal to the check amount. So if the check is coming for 50,000 and a customer is having a 50,000 of amount, then that check can be honored. Second is talking about checks sent for clearance not treated as funds or cash available. So whenever check is sent for collection, you will see that it won't be treated as cash in hands of the banker. When check is sent for collection, unless and until it is realized, it cannot be said that funds are available for clear funds are available. So when you deposit a check in a bank, it goes for collection. Then at that time you can see the balance, but it is yet not clear. So such balance is also known as shadow balance or unclear balance. Once that check is cleared, which is sent for collection, then the funds in the hands of the banker would be clear balance. So only the amount which is there in the clear balance or the amounts which are realized can be understood as sufficient balance of funds. So what if a customer is has issued a check of rupees 50,000, balance in his account is 40,000, and some check which is subject to realization is showing balance of rupees 20,000. So 40,000 is clear balance, 20,000 is unclear balance, and check amount is of rupees 50,000. Here in this case, bank would be justified in not honoring this check. Reason being, the clear balance is only rupees 40,000. So you have to remember that check which are sent for collection won't be treated as cash in hands of the banker until and unless they are realized. Third is banker not to disclose the payee by how much amount the account is falling short. For example, I am having a check issued by Mr. X for rupees 10,000. I go to the bank for getting that check cleared, or if they deposit that check in the bank for clearing, and bank is not able to honor the check because the amount in the account is maybe 8,000. So I go to the bank as a payee and I ask ki how much amount is falling short. So in this case, bank is not to disclose the information of customer's account because bank is also under obligation to maintain secrecy. We have already seen this in earlier lectures. So this is all about sufficient funds. Coming forward to funds properly applicable to payment of check. What does this mean? So there is a chance that customer may be having several accounts in different capacities, maybe as a partner or maybe as a proprietor, maybe in joint account and a single account. So in such case, if a check is issued in the savings account of that particular customer, then only that account is becoming relevant, or that account has to be considered. So suppose if I am holding an account in a bank in 4 different capacities and I am sending or I am issuing a check in one personal capacity, say I am having a account in bank as a partner or as a director of certain company or as a joint account with someone else, and I am having a personal account and I have issued a check from my personal account. So if it is falling short and all other accounts may be having the amounts, still those cannot be utilized because they are in different capacities. So it is essential that account on which a check is drawn must have sufficient funds. Next is about earmarking of funds. So there are some funds which are earmarked by the customer for some specific purposes maybe. So such funds also won't be available for honoring of the check. What if there is a debit balance in current account? If there is a debit balance in current account, obviously check cannot be drawn on the basis of his fixed deposit with the banker. So I am having a current account which is in debit balance. I am also having some FD receipts or fixed deposits with the bank. So can this fixed deposit be utilized? No, they cannot be utilized. So debit balance in current account, check won't be honored. Talking about overdraft account. What is an overdraft account? Overdraft account is a facility which is credit facility given by the bank and which is having a drawable limit. So suppose I have been sanctioned with 5 lakhs of overdraft facility and I have already utilized some 3 lakhs or 3.5 lakhs, 1.5 lakhs still remains. And if I am issuing a check which is under this amount, so maybe 1 lakh or 50,000 maybe, so is bank under obligation to honor this check? The answer would be yes. It is a banker's obligation to honor customer's check up to the overdraft account or limit which is sanctioned by the bank. If this limit is reduced, then customer should be issued notice of such reduction so that withdrawal would be served by him accordingly. Suppose there is a past practice which is existing between a banker and a particular customer. Say I am having an overdraft account with withdrawable limit of 50,000, right? And I have issued a check of rupees 40,000. My limit is already utilized up to 20,000, so only 30,000 remains. 35 or 40,000 check cannot be honored. But generally in usual practice what happens is banker does call the customer, being his regular and loyal customer, that this much amount has been received and you are already overdrawn above limit, so what should be done? So your customer assures that please honor the check. I will make the limit by this day end. I will make that withdrawable limit up to I will make the payments up to the withdrawable limits. So in such case, if such past practice is prevalent between banker and customer, this would be an implied arrangement to overdraw above given limit. So banker shouldn't discontinue such practice without giving prior notice to the customer. So this is all about the proper applicability of funds in payment of check. Moving forward, banker must be duly required to pay. What does this mean? So banker would honor the check if there are sufficient funds, if the account from which the check is issued is having a sufficient fund. Third, if check is proper, complete and in order. So what does this mean? So if there is a mismatch between the funds in the words and amount in words and amount in figures, or if there is some difference in signature, so here it can be said that check is not in proper order and bank can dishonor such check. It should be presented in proper time. What does this mean? The check from the date of issuance is valid for 3 months. Earlier it was 6 months, but after 2012 the validity is reduced to 3 months. So if the check is coming after the validity period, it is considered as a stale check and such check won't be honored. If a post-dated check is issued, then also it would be dishonored by the banker, because order of the drawer becomes effective only on the date of the date given in that check. So all these things, if they are conditions are existing, then bank can dishonor the checks. Otherwise, in any condition, bank cannot deny honoring of the checks. What would happen when Garnishee order is received by a bank? Now, what do you understand by Garnishee order? Garnishee order is basically issued under CPC Order 21 Rule 46. You must have already studied this. But let me tell you, Garnishee order is such order wherein a court has issued this order because there was one creditor and a debtor. That debtor is the customer of the bank. That debtor is not able to repay the debt to that creditor, whoever the creditor may be, and the creditor is not having any kind of negotiable instrument for payment of such debt, then it is not left with any option but to approach the court. When such creditor is approaching to the court against the debtor who is the customer of your bank, say, so the court will issue an order which is known as Garnishee order. The creditor who has been gone to the court is known as judgment creditor. The debtor who is customer of your bank is known as judgment debtor, and the bank in this case is known as Garnishee. Account of customer with the banker will be suspended, and banker would be an obligation not to make any payment when such Garnishee order is received. The account of the customer would be suspended and the obligation not to make payment after the receipt of Garnishee order. So Garnishee order would be of two types. One is order nisi and order absolute. Order nisi is what is the first time when court is directing the banker to stop the payment. Such order is called order nisi, where court also seeks the explanation from the bank as to why the funds in the said account should not be utilized. The banker here would be prohibited from paying the amount which is due to his customer on date of receipt of this order nisi. Once the order nisi is received by the bank should immediately inform the customer that dishonor of any check may be avoided. So if a Garnishee order is issued by a bank should immediately inform the customer that such and such Garnishee order is received against you. Such and such Garnishee order is received against you, and that is the reason you are supposed to, as a bank, we are supposed to stop payment of all the amount which is there in the balance in the account. So here after we won't be able to honor the check. So dishonor may be avoided, right? So also bank has to file its explanation with the court, and then court will issue a final order which is known as order absolute, where the entire balance of the account or the specified amount would be attached and it has to be handed over to judgment creditor. So once order absolute is received by the banker, bank would be bound to pay the garnished funds to judgment creditor. Thereafter, the to Garnishee order, first is the amount attached by the order. So Garnishee order may attach either entire amount or the specified amount. The banker would have to earmark or move this account to the suspense. So if it is for the specified amount, say the Garnishee order has been received for 30,000, the balance in the account is 50,000. So that 20,000 can be utilized by the bank to honor other checks, but 30,000 rupees cannot be paid unless and until the Garnishee order is becoming absolute, and once it is becoming absolute, that 30,000 has to be paid by the bank to the judgment creditor. Generally, in regular practice, what bankers do is they transfer that attached amount as per the order to suspense account, so that the amount would be safe and cannot be utilized by the customer, or by mistake cannot be used by the bank itself. So there is a chance that bank may honor the check beyond the amount of Garnishee order, then bank would be liable to the court or judgment creditor. That is the reason such amount would be transferred to suspense account, or it would be earmarked, so the payment won't be done for that particular amount of Garnishee order. Now the order of the court restrains the banker from paying the debts due or accruing due. Now this is with respect to the overdraft account of the customer. So the bank is not a Garnishee with respect to the unutilized portion of the overdraft or cash credit facility which is sanctioned, and such unutilized portion. So in case of overdraft facility, basically bank is the creditor and the customer is the debtor. So if the facility is granted for certain X amount, here that facility is only a guarantee by a bank under an agreement that yes, we would allow this much amount of debt to you. So Garnishee order cannot attach overdraft accounts. Remember that. So it was given in Karnataka by Karnataka High Court in Canara Bank versus Regional Provident Fund Commissioner. In this case, the Regional Provident Fund Commissioner wanted to recover the arrears of Provident Fund contribution from defaulters bankers. From what? From the unutilized portion of the cash credit facility. The High Court said that bank cannot be termed as garnishee with such unutilized portion of either overdraft or cash credit facility, because here basically the banker's position is of that of creditors. So for example, a certain bank is allowing a customer to overdraw to the extent of rupees 5,000. Actual overdrawn amount is rupees 2,000 only. So balance 3,000 is not overdrawn, right? But this 3,000 can also not be attached by Garnishee order because it is not debt due to the bank. Always remember that. And of course, when Garnishee order is received, banker has right to set off any debt which is owed by the customer before the amount of Garnishee order is determined. So we will discuss the rights of rights of banker with respect to lien and set off in next coming lecture. But remember that in case of Garnishee order, first the debt which is due to the bank can appropriate the funds and then only can appropriate it to the Garnishee order. So customer's liability towards bank would be at the priority. Also here the banker would be entitled to combine two accounts in the name of the customer. If the account is showing debit balance and the credit one, then net balance is arrived by deducting the former firm letter, but both accounts should be in the same capacity which is held by the customer. Third thing talks about Garnishee order attaching the balance standing to the credit of principal debtor. So Garnishee order does not apply to any amounts which are subject to realization. So if any check is sent for clearance and the amount is uncleared, then Garnishee order cannot attach this unclear amount. So amount of such unclear check which would be credited to customer account, then the Garnishee order won't be applicable on that date to such uncleared amount. Always remember that. Then Garnishee order also cannot attach the amount which are deposited in customer's account after the Garnishee order has been served on. So remember, the Garnishee order would apply only to the current balance at the time of the order is served. So it won't be in prospective operation. So today if the amount Garnishee order has come for freezing the total amount which is standing to the credit, then as of date today whatever is the balance in the customer account would be freezed for the Garnishee order. If any credit is coming after the Garnishee order has been received, then that won't come under the purview or ambit of this Garnishee order. So it won't have any prospective operation. Then Garnishee order won't be effective on payments which are already made by the banker before it is served. So before the Garnishee order is served, if the amounts are made by the payments are made by the banker in regular course of business, then Garnishee order won't be effective to them. So it won't have any retrospective effect also. It won't also have any prospective effect. What about Garnishee order where it won't be applicable to? So Garnishee order won't be applicable to money held abroad by the judgment debtor and securities held in safe deposit custody of the banker. So many a time a situation based problem comes which asks that what would happen to the safe custody articles or amount in safe custody with respect to Garnishee order. So Garnishee order won't be able to attach the securities which are held in safe custody of the banker as well as the money which is held abroad by the judgment debtor. Always remember this. Now what would be the application of Garnishee order with respect to joint accounts, partnership accounts and trust accounts? With respect to joint accounts, if the joint account is opened in name of two or more person, only one of them is judgment debtor, then that joint account cannot be attached. But if the joint account holder are joint judgment debtors and any legal proceedings are against the joint debtors, then joint account can be attached. But if the case where debt is jointly taken by two or more, but individual accounts are also there with the bank, then in such case individual accounts won't be attached. Always remember that. In case of partnership, now as you know, in case of partnership, partners are also personally liable as well as severally liable. So the partner's personal accounts can also be attached in addition to the partnership account. But reverse, it won't happen. So if a judgment debtor individually as a partner, any garnishee order is coming in that partner's name, then only his individual account may be attached and partnership account won't be attached. What about trust account? So trustee who is holding the funds or property of someone else for benefit of beneficiary, an account is also opened in his personal name in his capacity as such, then cannot be utilized for paying of personal liabilities. So trust, if he is a trustee and account is opened in trustee in capacity of trustee, then it won't be utilized for payment of personal liabilities. Now these are all conditions which we discussed that when bank can be justified in not honoring the checks. What would happen when garnishee order is received? But if bank inadvertently or there is a wrongful case of dishonor on part of the bank, then as seen in section 31, we have already said that there would be loss or damage where bank would be liable to that such loss or damage. So what does this loss or damage refer to? It refers to monetary loss which is suffered by the customer as well as the loss of reputation. So here bank would be liable to compensate not only for the actual monetary loss which is caused because of the wrongful dishonor, but also for any loss which is caused to the reputation of such person, may it be in personal capacity, there is a reputation loss, or may as a businessman also it is a reputation loss. So in such case, loss of reputation also has to be made good by the banker. Of course, in case of businessman, the loss of reputation would be more. In personal account, loss of reputation would be not considered as grave as in case of businessman, because credibility is disturbed in case of business. So banker would be liable for all this, actual monetary loss as well as loss of reputation. Always remember that. So bank has to be careful while dishonoring a particular check. It can dishonor the check only in the cases which are discussed above. Otherwise, bank cannot dishonor the check if it is in order, if the account is having sufficient funds and is issued in proper capacity. Always remember, bank is under a liability for such wrongful dishonors, and it can be a difficult situation for a bank. So always banks are careful while dishonoring the check. This was all about banker's obligation in respect of honoring of the check. In next lecture, we are going to discuss banker's right. Now we have already discussed the banker's obligation. Now we are to discuss banker's rights as well as banker's, so lien and set off are the banker's right which are available to the bank. So this would be discussed in the next lectures. Do let me know if you like the video and do subscribe to the channel. Keep studying. Bye. Thank you.